Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thank you for joining us. Hey, listen, it's July. It's past July 1st, which means we have several new laws that have gone into effect. Now, we spent a lot of time talking about Senate Bill 5078 and the standard capacity magazine ban. Then the Supreme Court decided to take a wrecking ball to a bunch of things. That gave us an opportunity to do a bunch of real fun videos. And so I haven't had a chance to really get this information out. It's a little late, but it's very important to you. As we know, House Bill 1705 went into effect on July 1st, the same date as the standard capacity magazine ban did as well. And that has some very important implications for you, the lawful and responsible gun owner here in Washington State. Today, we're going to have to spend a few minutes talking about what's the rule on untraceable firearms in Washington State today. Okay, so the issue we're talking about today is House Bill 1705, which we covered all through the legislative session and our long odyssey of having our Second Amendment rights stripped from us. And what you may recall from the bloodbath of a legislative session that we had this year is that House Bill 1705 is complete regulation and banning of what we call untraceable firearms, 80% lowers, and things such as that. Now, there are some effective dates where certain provisions of this law go into effect, and it's confusing a lot of you. And I have to be honest with you that the statute is a little inconsistent. I'm a little confused myself. What I'm going to try to do today is take House Bill 1705, break it down into small digestible pieces so that we, the lawful and responsible gun owning community, can understand what the hell's really going on here. Okay, there are two effective enactment dates that you need to be aware of about House Bill 1705. The first date of enactment was July 1st of this year. That means that this bill is in effect as we speak today, okay? That means every provision in this bill is in place. Now, some of those provisions have what we call sunrise provisions. That is, that they don't kick in until a date certain. They are articulated here in the bill, and I'm going to explain that. But the two dates you need to be aware of: July 1st, 2022, that's the date that this legislation went into effect. March 10th, 2023, that's when some of this other legislation actually kicks into effect, and there will be more requirements as it relates to untraceable firearms. Okay, now, the first thing that House Bill 1705 does is it amends RCW 9.41.190, which lists many of the prohibited firearms in the state of Washington. The statute prior to the enactment of 1705, specifically 941.190 sub D, read as follows: except as otherwise provided in this section, it is unlawful for any person to D, manufacture an untraceable firearm with the intent to sell the untraceable firearm. Okay, so previously you could not manufacture an untraceable firearm if your intent was to sell it. Now, there are two changes here. They're mildly inconsistent, but I do believe that both of these are in effect. The first one is an amendment to 941.190 sub D. The new section D now reads, except as otherwise provided in this section, it is unlawful for any person to D, manufacture, cause to be manufactured, assemble, or cause to be assembled an untraceable firearm with the intent to sell the untraceable firearm. So, as you can see, before with the definition of manufacturing, there was some wiggle room for people. Did I manufacture or did I just assemble the firearm? I've never manufactured any type of an AR platform. I have assembled them by dropping uppers on lowers and popping pins in and things such as that. The new definition clearly says, hey, any kind of assembling, manufacturing of anything of an untraceable firearm with the intent to sell is unlawful. But wait, there's more. Now, in addition to expanding the scope of manufacturing and assembling with the intent to sell, it is, in the opinion of Washington gun law here, that merely manufacturing a untraceable firearm right now, starting July 1st of this year, is in and of itself unlawful regardless of what your intent is. Section 4 of House Bill 1705 made it very clear that a new RCW was to be added to 941, and that new RCW would read as follows: no person may manufacture, cause to be manufactured, assemble, or cause to be assembled an untraceable firearm. So that new section, which was supposed to go into effect on July 1st, says, listen, you cannot assemble or manufacture an untraceable firearm, period. We don't care what your intent is. Whether you're going to sell it or not, it's irrelevant. But right now, for the sake of posterity, it is the opinion of Washington gun law that the assembly and manufacturing of an untraceable firearm in Washington State in July of 2022 is unlawful under this statute. Now, as you also heard me say earlier, there's a sunrise provision. There's some provisions of this bill that go into effect at a later date. That later date is March 10th, 2023. What happens effective that date? Well, according to Section 4 of House Bill 1705, the following occurs. After March 10th, 2023, no person may knowingly or recklessly possess, transport, or receive an untraceable firearm unless the party possessing, transporting, or receiving the untraceable firearm is a law enforcement agency or a federal firearms importer, manufacturer, or dealer. And there are only limited number of exceptions to this, firearms which had been rendered inoperable. And then, of course, you can exempt your firearm from this untraceable prohibition by making it a traceable firearm, because the section says that the law does not apply to any firearm which has been imprinted by a federal firearms dealer or other federal licensee authorized to provide marking services as provided for in Section 6 of this Act. So yes, the one way that we can grandfather in an untraceable firearm is to make it a traceable firearm. So, as I read the law today, it is unlawful here in July of 2022 to assemble or manufacture an untraceable firearm with the intent to sell. I also believe it is unlawful to manufacture or assemble an untraceable firearm for any purpose. Effective March 10th, you will not be able to possess, receive, transport any untraceable firearm or any 80% lower unless it's, of course, printed with a serial number, thus making it a traceable firearm. Now, there is one big, gigantic loophole to all of this, and this is the most important thing. This is the point I want you to take from all of this. None of this applies to any firearm which was made prior to July 1st of 2019. Untraceable firearm is now defined in 941.010 subsection 41 as follows. Untraceable firearm means any firearm manufactured after July 1st, 2019 that is not an antique firearm and that cannot be traced by law enforcement by means of a serial number affixed to the firearm by a federal firearms manufacturer, importer, or dealer in compliance with all federal laws and regulations. So all of this that I am talking about only deals with an untraceable firearm if it was manufactured, that is, turned into a firearm sometime after July 1st, 2019. Now, I know what you guys are asking. Well, how the hell are they going to be able to tell whether I built this in June of 2018 or June of 2020? The answer to that is, in all likelihood, they can't. Because there are no sales record for you receiving the untraceable receiver. When you received it, it was nothing more than a chunk of aluminum. There was no 4473. There was no traceability. There are no records other than sales records from perhaps the manufacturer. So I know that most, if not all of you who have untraceable firearms, you've had prior to July 1st, 2019. If you have not, however, if those firearms came into your existence after July 1st, 2019, those untraceable firearms are now subject to the provisions of House Bill 1705. A violation of this law moving forward, first offense is a civil infraction. It's a $500 ticket, okay? Second offense, though, is a misdemeanor, punishable by up to 90 days in jail and a $1,000 fine. Second or subsequent offense is a gross misdemeanor, punishable by up to a year in jail and a $5,000 fine. There is a separate charge for each firearm which is unlawfully possessed. Listen, you may have more questions about untraceable firearms, House Bill 1705, or any of this other crazy stuff going on with your Second Amendment rights. And if you do, don't ever hesitate to contact us at WashingtonGunLaw.com. Or, of course, you can call us directly at 425-765-0487. Now, let's remember, part of being the lawful and responsible gun owner, like we preach all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.